Good evening, one and all there. I'm so sorry that we had some technical issue in getting some of our participants joining the session today. Uh, I welcome you all for the ISTD's Learning Series Part 2, which we are starting again after a gap of some time. We have had a successful learning series Part 1 previously in the last year. And we had to give some gap because of certain COVID issues and certain things. But we are back again. So we welcome you again, sir, each and everybody, ladies and gentlemen. ISTD Ahmedabad, let me just quickly give you a brief about ISTD Ahmedabad. Is a non-profit organization. We have chapters across India. NHQ is based out of Delhi. And Ahmedabad is one of the chapter which we have it here. Besides that, we have 7 chapters outside India as well. This particular chapter is being governed by a management committee, which is headed by our chairperson, Dr. Neela Panchal. My colleague Tanviji is a vice chairperson, and then myself as an honorary secretary of this chapter. Besides me, we have honorary treasurer, Mr. Chati, and NC members, Dr. Chuk and Uday Paliwalji, and our national council members, Mr. Yash Rathi, Dr. Reena, and Dr. Paresh. On behalf of ISTD Ahmedabad, I welcome you all again. It is my privilege to have and welcome my esteemed panelists today. We're honored to have Dr. Baxi, Dr. D.C.Baxi, who is an additional retired additional Labour Commissioner of Government of Gujarat, with a vast experience in both government services, more than 30 years, and served various other positions in academia as well, consultants, and currently engaged with a lot of universities, including the Labour Law Judicial Academy of Gujarat High Court. I'm joined by another panelist of ours. He's also a person of repute, Mr. Mankodi, who is the GM HR from Astral Pipes Ltd. He's also an honorary secretary of NHRD. He has a vast experience in both an HRD field. Also holds HR portfolios with various big organizations in Ahmedabad and Gujarat. So he holds a Gujarat LLB degree from Gujarat University and Labour Welfare from Gujarat University. He has completed his postgraduate qualification on new labor codes also. He has, again, a vast experience of more than 30 years in HR, IR, training, development, and welfare, compliance, licensing, and worked at different industries like Urban Limited, Torrent Group, Celeris Biochemicals, and currently working as General Manager, HR Astral Group, as I mentioned to you. We have our own, another panelist, our own honorary treasurer, Mr. Yogesh Chati, with about 22 years of experience in training in various organizations, public sector like ONGC, Ahmedabad, Mehsana Division, private companies like Ford Motors, Hitachi, Rail Power Electronics Limited, Torrent Power, Honda Motors, to name a few. Currently working as training officer in Mumbai, IIWE. So, good evening once again, gentlemen. This was about a brief introduction of who we are and who are joining us today. I'm sure we have received about 100 participants joining us today. I'm sure they have been able to join us finally with initial hitches of technical glitches there. And before taking much time of us now, let me quickly invite our panelists to come on board and take the stage. Thank you, gentlemen.
Thank you. Thank you, Manishji.
Yeah, thank you, Maheshji, for inviting us on the current topic with respect to recent labor codes enacted by Government of India, Ministry of Labour.
Let us have Mr. Mankodi ji to have this session started, sir. So what are we going to do is, we have a set of questions. What we're going to understand today is uncoding the new labor codes, which have recently been passed by Government of India in recent last 3 years or so. But we have found out there has been a huge gap in terms of understanding what these new codes mean to specifically the SMEs and MSME sector in and around Gujarat and otherwise. And yet this particular field is unknown to many. So with this session talk show, we're going to unfold certain certain crucial knowledges and try to understand how it is going to possibly impact different industries which you come from. So how I'm going to do is I'm going to welcome Mr. Mankodi to have his own sessions, who's going to represent the industry, and Mr. Yogesh Chati, on the other hand, he'll be also taking certain questions from the industry as well as from the workers' union sides. So over to you, Mankodi sir. Let's say you have a questions there.
Yeah, I would request Mr. Yogesh Chati to start with his questions. Mr. Yogesh, please. Yogesh bhai?
I think Yogesh bhai is having some mic problem. It is a network issue.
Okay, fine. So on behalf of Yogesh bhai, I'm taking opportunity to start the first questions, which on behalf of Mr. Yogesh Chati. Good evening, Dr. Baxi.
Good
Now, we
evening.
would like to, in this context of entire new labor code, we would like to understand from you that basically what is the genesis of labor code? Can you just enlighten us with the genesis and why this simplification in labor laws are required? Can you just enlighten us, please?
Yeah. First of all, to begin with, thank you very much, ISTD, for inviting me to have a deliberation on the subject. And before I touch the subject, I would like to draw two lines of my experience and what role and responsibility I had when I was on the board in drafting laws, amending laws, and of course input on the craft of this existing labor codes, which we are going to discuss in a quick succession by, as Manish ji has rightly explained to begin with, that FAQ have been designed in such a way that it will give enough understanding in decoding the salient features and how it will be useful to the stakeholders. But to begin with, always how laws are enacted, what has made the Government of India Ministry of Labour to have this. So the genesis of the subject. Friends, quickly explaining the event since 1990, that India entered into the global economy, and since then there was the deliberation from the stakeholders to revisit the plethora of labor laws. And to address this issue, Second National Commission on Labour was constituted in 1999, which gave a report in 2002 June. I was fortunate at that point of time in something 2001 to give a status paper on behalf of state government to the Second National Commission on Labour. So I can say that since then I am roped into this activity. But point is, the Second National Commission on Labour, when normally commissions are constituted, they have been given terms of reference on which they need to deliberate on the by way of recommendation. So two terms of references were given to Second National Commission on Labour. First was the simplification of labour laws, and second, to have an umbrella legislation for unorganized workers. So on these terms, the commission deliberated and gave a detailed report in 2002 June. Of late, nothing could happen, but in 2014 onwards, the ease of doing business, use of information technology, and most of the labor laws have lost the relevancy with the present context. It was a need of the day to revisit the plethora of labor laws. And in light of that, reading with the recommendation of the Second National Commission on Labour, they have recommended that the plethora of labor laws, in all, friends, if you look to the 2 volumes of industrial law, you will find nearly 100 labor laws, of which 44 are active and a few are the state enactments. So these 29 labor laws, having to their nature of deliverable to all stakeholders were classified under 4 different labor codes, and this is how the labor codes have taken birth. And of course, the simplification was a need of the day, keeping the global context, WTO regulations, ease of doing business, inviting entrepreneur in the country and the given state. Everybody is asking to reduce the plethora of labor law, simplify them, so that it is easy for the entrepreneur to comply the law, as well as without negotiating with the constitutional rights of the workers. So that is how the labor codes have come on the board, and why the simplification was required.
Yeah, thank you, sir. It gives us a background of the entire labor code enactment. As you have mentioned that 29 labor laws were merged. Now, what are those codes? Can you just give us the names of such labor codes?
Yeah, in all, as I said and you rightly reciprocated, that 29 active labor laws enacted by Government of India, which were merged and classified to their nature of deliverable to the stakeholders, were put under 4 different titles. The Code on Wages 2019, that was passed by the Parliament and assented by Honorable President in August 2019. Second is the Occupational Safety, Health and Working Condition Code 2020, that was passed on 28 September 2020. And in Code on Wages, 4 labor laws are merged. In Occupational Safety, Health and Working Condition, existing 13 different labor laws are merged. Third is the Industrial Relation Code, also passed on 28 September 2020, where 3 labor laws are merged. And fourth is the Code of the Social Security Code 2020, both also passed by the Parliament and assented by Honorable President on 28 September 2020, where 9 labor laws are merged. So thus, in all, 4 labor codes amounting to merger of 29 different labor laws are passed by the Parliament, and we are awaiting the formal notification for the date of its implementation.
Right. So having said all this background, now would like to go into details of each code, and would like to ask you, sir, that the first is, what is the Code on Wages, and which labor laws are amalgamated in Code of Wages 2019, and what are the salient features? Just to start with on Code on Wages, please, sir.
Okay. Sure. See, as I said, the Code on Wages was the first labor code, was passed in August 2019 in Parliament, and subsequently as a part of lawmaking procedure was assented by the Honorable President of India. There are 4 different labor laws are merged into it. The first one is the Payment of Wages Act, which is of 1936, the Minimum Wages Act 1948, the Payment of Bonus Act 1965, and the Equal Remuneration Act 1976. So in all, these 4 labor laws are merged under one title as a Code on Wages 2019. Now coming to the salient features of the Code on Wages, I would like to friends let you know that before I touch the subject, we must have some basic knowledge of what is existing as of now, and then I will try to quickly react to what has been put in the code by way of different thing to address the new era. Friends, practically all labor laws are focusing on the rights of the workers, and which is the provision as of now, because this codes have not seen yet light of the day. In Code on Wages, something different, that is the definition of employee, was first time introduced in labor laws. So irrespective to whatever the position individually holds in the company, but so long as he or she falls within the ambit of employees, he or she has some protection under the code on wages. Then payment of bonus act, friends, which is a part of this code on wages, the bonus is applicable to the salary limit of 21,000 with basic and DA is the definition. It is, put in practice under this code that the appropriate government will decide the ceiling of wages for the purpose of payment of bonus. So this 21,000 limit may go off when this code is rolled out. Most importantly, friends, the definition of wages has been fairly revised. Now in corporate sector, without getting prejudice or a bias or anything, normally CTC is the word popularly used, where the constitutional liability on the shoulder of employee like PF, ESIC, professional tax, and so on, gratuity, even payment of bonus is put and accounted into the salary of the CTC of an employee, which was discussed at some point of time while this code was under process of enactment, that why the employer should account the constitutional liability which he is supposed to comply in accordance with the relevant act like PF 12%, he is supposed to deposit as a matching proposition, ESIC 3.25%, gratuity for completed year of 15 days if we got continuously 5 years of job, bonus as per the act, and so on. So the wages definition has been restructured under the code on wages. Then the first time in the country, it was a recommendation of course, a second National Commission on Labour. And friends, all of you know that labor is the subject on the concurrent list of the Constitution of India. So every state has its own, capability by constitutional base to have their own legislature or can put whatever procedure they deem fit to address the state situation, because every state has a different geography, economy, natural resources, nature of workforce, nature of even entrepreneurs. So every state used to fix different minimum wages. To address the issue, the first time the national floor level minimum wages was put in the code on wages, that no state will fix the minimum wage below this floor level wage. That is one of the significant salient feature if I have to answer a question as a 30 years of person in the department. That will certainly address the spirit of Article 40, that the living wages, need wage wages, minimum wages. So floor level minimum wages that Government of India will decide maybe on a regional base, and no state in a given region or a country will fix lesser than that floor level wage. Was the first time introduced. Currently, friends, in the minimum wages there are only 3 categories of workforce defined: skilled, unskilled, and semi-skilled. The highly skilled category was first time introduced in this. Second, friends, in case of non-payment of wages or less wages or non-payment of bonus or otherwise, presently one has to go for a recovery under respective act. In case of minimum wages, the one has to go to the labor court to file the recovery, be it a non-payment or a less payment of wages. And in case of non-payment of bonus or illegal deduction under the Payment of Wages Act, the labor court is the last remedy. So one has to move on to the judicial forum to redress their issues of non-payment or a less payment. That has been tried to diluted here, and the powers of issuing recovery and making appropriate order on such complaint or such representative have been delegated, or I rather legislatively authorized to the government officer nominated by the state government, not below the rank of under secretary. Just I add into it that state rules, draft rules I have scanned through. Since it is not final, I cannot have a final say, but here in that case, in state government, the authority, that is Assistant Labour Commissioner, have been empowered to hear and decide the case of less payment or a non-payment of be it a bonus, wages, illegal deduction under the payment of wages act, etc. Then, friends, earlier the payment of wages act was made applicable to those who draw salary up to 24,000. Now that limit has been lifted. As I said when I begin with, the employed term has been included. So all employed class has been tried to protected by way of this. And last, most significantly, is the compounding or composition of offences. Friends, I will let you know, as of now, today, if so is the situation, that violation of all labour laws amount to criminal case. And I can say with pride and privilege, when 2015 Gujarat made a state amendment, it's I who came out with the deliberation that potential criminality of violation of labour laws should not be equated with other crime being where these cases are being trialed. So there has to be some window subject to some rider who compound the offences before the government authority, and I succeeded in convincing the higher ups in the law fraternity in Gujarat, and we could roll out by way of state amendment. And the same thing, the one who has drafted, rather who is instrumental in drafting this code at national level, have gracefully accepted honoring the state amendment and have put into the practice into the 4 labour codes. So this is Viral Bhai, the salient feature. There may be many more minor changes in the code on wages, amalgamation of 4 labour codes, but keeping timeline in a view, I am just restricting here that these are the major things which have been put in practice under the code.
Right. Understood, sir, your point. But having said all these aspects on the code on wages, what is so special for employers and employees in this code, specifically in this labour code? What is so special for employer and employees? Because it's most important for all of us to understand.
True. I let you know, first of all, to begin with, the plethora of labour laws are reduced. So from employer's perspective, they have to look only on one labour code here with reference to wages. So number of records and registers, be it online or offline, will be reduced. Second thing, all compliance will be online. There is no need to have the physical transactions of papers. Will address the ease for the employer side. Third, that the term inspector cum facilitator have been introduced into all the 4 labour codes, which I am generally saying at this point of time. Friends, I let you know that the normally inspectors are being, of course I was also part of the system, but their job is to find out the faults from the where the law which they implement and try to see that they are put in compliant form. Now, by virtue of the, in 2003, government of Gujarat has come out with a policy that all inspectors should behave like a friend, philosopher and guide. But that was only a practice, rather a policy. And policy, when it is not supported with the legislature, it is very difficult to implement because it is like a directive principle of state policy. So it was legislated, the term inspector cum facilitator was defined, and he is supposed to facilitate the stakeholders, be it a workers, trade union or the employer, rather than showing the eye of the litigation, is legislatively put under the obligation to behave as a friend, philosopher and guide and if not, he has to face the consequences. Then the mobile application has been launched in 2019 in Gujarat. But same thing, when this code will roll out, it will also be put into the practice. That when the officer will go and on real time base, they will have to upload the data of inspection which employer can see, the higher officer of that given inspector also can see, and that all he has to do within 48 hours. So his entirely way of working has been digitalized, so that everybody is make it responsible for whatever work they are doing. So that is from employer perspective point of view, that ease of compliance, reduction in records and registers, and of course full use of information and technology, and of course most importantly the compounding of offences to do away with the criminality of cases which one has to go attend the criminal courts and then all subsequent proceedings related to that. So that has been diluted without affecting the constitutional rights of the workers. There is a myth and misunderstanding. Let us be very honest on the subject, that government has in all the labor courts, there is an option. If employer does not come for the composition, there is always option of filing a criminal case, but that is optional. So a window has been created. Instead of going to the criminal court for violating the law, let us have the composition of whatever offences one has made before the bureaucracy authority. So that's what in favor of employer quickly reacting to it. With reference to when employees, the term employee itself is first time introduced. When rules will be rolled out, we will have a better clarity on it. Then the with reference to the informal sector, the floor level minimum wages will certainly safeguard their livelihood. The payment of bonus, of course, which the limit of 21,000 will certainly go, and more coverage to the more employed class also will be there. Then the provisions of the payment of wages of legal and illegal deduction was restricted to only those who draw salary up to 24,000 also have been taken off. The time limit of paying the wages was 7 and 10 based on the strength of the worker also have been reduced to 7, and most importantly the wages definition, which I started to focus that it includes only basic dearness allowance and retaining allowance. So any other allowance which is more than 50% will go to the wages. That is what the rider of the wages definition provides for. So it will be difficult for employer and better for employee to pass on the constitutional liability into the CTC. That's what quick reaction, that how it is in favor of the employee. And last but the least, the no discrimination in wages on a gender basis, of course, was there in Equal Remuneration Act, but in piecemeal legislature, it was nearly less focused. Being of 1976, focusing Article 14, right to equality, was not as focused as, and you also will Viralbhai agree, being across the system in corporate sector for 3 decades, you would not have find much on the Equal Remuneration Act. So this also being merged and trying to, addressing more a gender equality irrespective to any wage discrimination and so on. And last but the least, I say that the first time the transgenders also have been put under the ambit of protection of the all 4 labor code. I just say before I conclude on the core question, the basic issue, which I've been talking and teaching to various places, labor laws are interlinked. So if we really want to understand the real, benefits of the labor codes, all the labor code needs to be read simultaneously, understand simultaneously, because one has bearing on other labor code by one or another way. So that's what I just conclude with the last remark, that it has to be read in true spirit, simultaneously. I mean, then you will get the real, I mean, idea of what is being really done for the both the stakeholders.
Yeah, thank you, sir. Now, taking the entire session to the next area, that is on Industrial Relations Code 2020. Sir, can you just give us brief on what is IR Code 2020? Which current acts are amalgamated in IR Code, and salient features of Code 2020, IR Code?
Okay,
Bakshi, sir,
yeah,
please.
yeah. So, friends, after code on wages, the another code which was passed in on 28 September 2020 is the Industrial Relation Code. The idea is to, regulate the registration of and cancellation of trade unions, the working condition by way of standing order within the premises of industrial establishment, how need to be regulated, and of course investigation and settlement of industrial dispute and related matter is the object of this industrial relation code. Friends, you know that the industrial productivity efficiency is directly proportionate to the industrial healthiness, harmony, and industrial peace in a given state and in given industry. So these three different laws, that is the Industrial Disputes Act 1947, the Industrial Employment Standing Orders Act 1946, and the Trade Union Act 1926, are merged under the Code on Industrial Relations Act, Relation Code 2020. The referring to the salient features, friend, as I said, that term employee has been introduced. So far, if you look to the definition of workmen in standing order as well as the Industrial Dispute Act, it has very restricted ambit to only workers. Now here the employees also will be safeguarded. That was the strong recommendation of the Second National Commission on Labour, that after all, whoever, be it a vice president, president, or whatsoever hierarchy, after all, he is an employee and need to be safeguarded by one or another means. And once rules will be out, we will be having more clarity how the lawmakers deal with. Then the revised definition of industry. As of now, I'll not dig much into the legislative part, but the initially the definition was based on the Bangalore Water Supply and Sewerage Board versus Rajappa case, a triplet test popularly known as. We'll have a different dilution and maybe philanthropic organization, trust, hospitals, academic institution, local bodies will be kept out of the ambit of this code on industrial relation. So that is the another change we can say. Then there are multiplicity of authorities under the existing format of law, that the conciliation officer, labor courts, industrial tribunal, court of inquiry, board of conciliation, etc., which also have been reduced. We all believe and we must agree, friends, that if I have to address the multiple authorities, then it will be very difficult for me as whatever stakeholder I am, be represent the employer or employee, will be very difficult to understand and go ahead. So most important thing, friends, I will let you know, which I strongly believe, that in-house grievances redressal forum have been tried to strengthen under this code. What we say, घर का झगड़ा घर में रहता अच्छा है. Having said so, the grievances redressal committee is the significant point, because before going for any further escalating the hierarchy, first of all, the organization should try to address within the grievances redressal committee, which is statutory under this ambit of act. And then, of course, the labor court, which was one of the authority, have been removed from this industrial relation code. the very purpose, if I have to answer and understand whatever I have being a part of the system, if you look to the Schedule 2 and 3 of the Industrial Dispute Act, Schedule 2 provides the role, responsibility, powers and matter assigned to Labour Code, and Schedule 3 provides for role, responsibility and matters under the governance of the tribunal. Now, in working pattern, what there are some government directives that if the strength of organization is 100 or more, the issues of collective bargaining will go to the tribunal. If it is less than 100, will go to the Labour Court, and all reinstatement cases of individual nature will go to Labour Court irrespective to any strength of employees. So now one authority they have diluted. The very purpose of this all Labour Court is to ease of doing. Multiplicity of authority nearly discharging the same nature of function need to go up. So the overhauling of the existing labour judicial forum. Second, friends, I will let you know very honestly, if you look to the database across the country, restricting as of now to the Gujarat, industries are increasing. As of now, about 45,000 plus registered factories and 18-19 lakhs nearly shops and establishments in 33 districts across the state. Now industries are increasing, workforce is increasing. Obviously, we must have the directly proportionate relation that dispute also would have been increasing, but in fact it reversely proportionate to the increased industrialization, increased workforce, but disputes and filing into the labour courts and tribunals are reducing. Friends, in November I addressed, as the Manish Singh ji has rightly said while introducing me, I just completed my 28th year, that is completed 2 decades in teaching in Gujarat State Judicial Academy, where all trial court judges, labour court judges, member industrial tribunal and judges up to additional district and session judge are being imparted training, orientation, updates, etc. At that time also in November I addressed the labour court judges across the state in online mode. Also same thing, sir, that filings are being reduced to reasonable extent in spite of the growth. So, if I sum up everything, then that nearly justify why the labour courts were removed. Then the most significantly, there was one act in Gujarat Industrial Relations Act, where the single bargaining agent concept, that is negotiation agent and negotiation council, were introduced. Reskilling fund, in case of termination, the employer need to deposit 15 days compensation into the reskilling fund, and that reskilling fund may have other sources of funding. Will groom the workers in search of, so that he can have a better livelihood. Compulsory notice in case of normal strikes and lockout, which was not at present, except the public utility service or anything pending before the forum has also been introduced. And if worker goes or employee goes on a mass casual leave at the strength of 51% or more, is to be treated as a strike. That is the amendment into the strike. And last but the least, the fixed term employment term has been introduced. Couple of employment which are of fixed term. So you can recruit anybody for the fixed term. Fixed term may be 3 months, 6 months, or to your choice as an employer. Only you need to address that the proportionate social security benefits are given, and that fixed term employee is getting salary and perquisite at par with that of the regular employee of company having similar nature of job. So Viral bhai, these are all the key salient features of the Code on Industrial Relations 2020.
So, sir, as you rightly mentioned about the fixed term employee, so can any person or any industry or any HR department can hire a person for say 3 to 4 years of tenure at a stretch in a one appointment letter as a fixed term? Is it possible?
Yeah, it is possible. If I go back to the 1947 IDA, Section 200BB does provide for contractual employment. And on completion of that given contract, that contract is made under the Indian Contract Act 1880. And on expiry of that contract, that given employee has no right to file the case of reinstatement or anything related to that, be it a non-renewal of contract or expiry of the contract. The
Right.
same period have been retrieved with value addition that such employee should get proportionate benefit of social security. So you can hire to your choice. That is why it is legislated. You know,
Okay.
for 3
Now,
4 years. There is no timeline defined in it.
okay. So it may be from 1 year to 5 years, whatever.
Whatever. Only you have to give salary at par to that of your regular employee discharging similar nature of job and
Right.
proportionate social security. As you understand that I have completed 4 years. If you have hired me for 4 years, then I'm not eligible for gratuity in present situation. But in case of fixed term, you have to give me gratuity of last drawn salary for completed year 15 days.
Understood. Understood.
Yeah. Okay.
Now, just couple of minutes back, we were discussing about the industry and Bengal water supply and all these things.
Yes.
So, is it true that the definition of industry is likely to be changed, or it is already changed under the IR code?
In IR code, it is already changed. Actually, earlier, if you go back to the 1947 ID Act, there was the industry does not include, and there is some listing below it in a present situation. But that notification has never seen light of the day. So today, we address the triplet test, and anything falls within that triplet test is an industry. Now that was of 47. Now we are in 2022. Lot of things have changed. So by legislatively itself, definition is changed actually. But then it has to be given effect by notification that from this date this will be, because that's the biggest issue which trade unions are opposing. As yesterday only I had one interaction with one trade unionist. I said, that may be different, look to different, provisions. But this definition has lost a relevancy which was of 79 Bangalore water supply in a present context. That's what I strongly believe. You can't afford to call Ambaji temple or a Srinathji temple as an industry. I mean, you need to have a revisit those situations was the need of the day.
True.
So yes, the local bodies are out of ambit of the industry. That is been legislated, but it has to be given effect by way of notification. That's only the area.
Right. So all are eagerly waiting when this code is to be implemented. Correct.
Oh, very true. Very true.
Now, Baxi sir, coming to the next, because in the limited time frame, we would like to understand all 4 codes as far as possible. So can you just give us the unique features of Occupational Safety and Health and Working Condition Code 2020?
Yeah. See, there are 13 existing labor laws have been merged. I'll not read it because, as such, we are late and timeline, we need to complete everything. The idea is under the code is 1 registration and 1 license. So any establishment employing 10 or more employees are under ambit of this code. So they need to get registration. Today, friends, Viral Bhai, you asked that how it is useful to the industries. So only one singular application with the help of few strokes of keyboards on e-Shram Seva, and that will be taken care of by all bureaucratic system. And there is a cap on the bureaucrats also to complete the application within stipulated time, failing which software itself will generate either license or registration and put into the mailbox of the one who has applied for. So some check and balance system already in the, then the more focus has been given to occupational safety and health of all employees. As I said earlier, it was restricted to workers. Now the ambit has been expanded, and the code provides for the National Occupational Safety and Health Board at national level, and every state should have a chapter. They will pass on the guidelines to all industries. Compulsory medical checkup once in a year, because onset of occupational disease is not sudden. So generating the data that will help in the onset of occupational disease. Then the definition of core and non-core activity, which was a unique feature, I will say, of this code, that always there is a dispute under which activity one can hire contract labor and under which activity one cannot hire the contract labor is been defined. And friends, this code was in fact rolled out drafted, and draft was final in December 2019. But in light of this pandemic, it was restructured, and Gujarat has transported as much as 20 lakhs of migrant workers to their native states during pandemic first phase. So some due recognition under this code has been given to the migrant workers, that they have enough contribution in the economy of a given state, and they were invisible so far due to the current Migrant Workers Act of 1979 does not provide that recognition to them, being a stipulated provision. But now the dedicated web portal, toll-free helpline, portability of ration card to them, and if they are working in the construction work, then the scheme, whatever their host state used to provide, that the destination state also will have to provide. That is how being articulated in this OSH code. And the definition of factory, registration, at present it is 10 or more workers use of power and doing manufacturing activity, and 20 or more power doing manufacturing 20 or more worker doing manufacturing activity without aid of power has been escalated to 20 in case of use of power and doing manufacturing activity, and 40 and more without power doing manufacturing activity as defined under the code. And last but the least, the expressive elaborated provisions on the role and responsibility of occupier, role and responsibility of the employee. Their accountability has been put more focusedly, because to avoid the industrial disasters and accidents. And one more, as a part of ease of doing business, the access to common crèches, access to common canteens, to cluster of industry also have been put in practice under this code, so that the current provision of 100 or more employee will need to have a compulsory canteen, 50 or more employees having female employee need to have a crèches. All these things will be diluted. It can be in a PPP mode. Government can also, or local bodies or industrial corporation can, or cluster of industry can contribute and have this kind of and of course compounding of offences, as I said, except in case of fatal accident, is also being permitted under this code. So these are the salient features. And of course occupational disease have been more focused. I said that will of course increase the cost of compliance on the part of employer. And one significant thing as well, which I skipped to put here, that to increase the women participation into the employment sector. Earlier, rather as of now, still since this code has not been rolled out, you cannot hire a female employee before 6 a.m. in the morning, and you can't recruit them after 7 p.m. So that restriction has been lifted in this code, subject to some riders. Of course, you can hire female employee into the night shift, second shift, or whatever, but such employee should give the consent. The arrangement of transportation should be made by the employer, and of course the assurance of the security of such employees. With that rider, you can employ or hire the female employees in night shift also. So these are quickly, the salient features of the OSH Working Condition Code 2020.
Okay. Now we would also like to understand from you, sir, that what is the unorganized worker and their welfare fund under this code? There are some provisions which we have learned.
Yeah, see, the unorganized worker, if the lawful definition, if I say that Section 2 of the Unorganized Worker Social Security Act 2008 provides for, if the strength of employee is at any workplace is less than 10, that is 9 and below that is unorganized workforce as defined under the Act, which is merged with the Social Security Code. And when they are out of the ambit of the code, because we will speak quickly on the Social Security Code in a couple of minutes, it is all the legislation are for the only organized sector. 10 or more employees, ESIC is attracted, 20 or more PF is attracted, 10 or more gratuity is attracted. But here the strength is less than 10, that is 9 below that. They are out of the ambit of legislature, and that is why the very purpose was to bring them under the schemes by way of the welfare board, and that may be funded by Government of India, state government, corporate social responsibility, and some other source of income which Government of India decides. And from that fund, this all unorganized worker who will be registered, given the identity card. Nowadays, if you look to the website of Labour Department of State or a central, you will find e-Shram, and that unorganized worker identification card has been issued to them by only way of self-certifying that he or she is unorganized worker, not member of PA, PSIC, Aadhaar, and contact details. So that's with the reference to the fund. And I start on my own, Viral, without troubling the timeline, that 9 different labor laws are merged under the last code, that is the code Social Security Code 2020, and few new terms have been introduced. The idea is to address the whole informal economy under the ambit and benefits of the Social Security. Few terms like a wage worker, home-based worker, platform worker, gig worker are introduced in this. An aggregator, I mean, if I say quickly about platform worker, there, arrangement outside the traditional employer-employee relationship, like, the knowledge process outsourcing, business process outsourcing, etc., are the area over and above, through online platform, like, everything is moving on e-commerce site. Not a correct time to speak, but Swiggy, Zomato, delivery boys serve the delicious food to the residents, are contributing into the economic system and circulation of economy, but they are invisible. They also, if they met with an accident, then they work on the commission base, but they certainly work for the certain class of platform aggregators. So they need to be safeguarded, and there is enough strength. In fact, unfortunately, 2021 census data has could not be conducted due to pandemic, but that will give some that this is another area which was to be addressed. And last but the least, the gig workers, that they are also invisible. And if you call some electrician at your workplace, and if he or she meets with an accident and happens something, there was no format to how safeguard, also likely to be under the code on Social Security. So that is all for now with reference to rest of the features are remain same. Quickly talking about the maternity benefit, the pandemic, and of course the new unfortunate event where female employee cannot conceive, the commissioning mother have been put under the ambit of this act, and mutual terms if agreed between employer and employee, the work to home with a different set of working pay structure also being facilitated to a female employee who is on a family bed. So anyway, quickly, about this.
Right. Thank you, sir. But my question remain still it is unanswered since many months. That when this code will come into force, what is your feeling?
See, what my feeling is, and of course, little interaction also I have made, that the area of the definition of wages, where the CTC and all this, which we have discussed enough, are little troubling the entrepreneurs. Rest all, Viral bhai, you were the one of the stalwarts in undergoing this PG course in Flexip Institute of BK. You have practically gathered everything in all the 4 labor codes. I would like to ask you before your apprehension then when this code will be rolled out. As 3-decade experience with very good background of academics, I'm putting you a question that what exactly you find that this is not in favor of either of the stakeholders.
True.
I mean, how you react to it? Is that really detrimental to the employer? It is really detrimental.
My experience after learning this code and having working in the industry for almost 30 years, it is a balanced view. That is my one-line answer. That is a balanced view has been taken by the government, appropriate government, and the more action-oriented orientedness will come when the code will be rolled out.
So that is what the answers your question. Only the work we used to discuss during our internal discussion in class or otherwise, that the area which pinches, which I could gather from reports of print media and other interaction, that the definition of wages troubles everybody. Putting employee under ambit of all the code is also troubling, because everybody will start agitating. But employees after employee, be it a vice president or maybe an unskilled worker, I mean, the labor laws are labor laws, and they need to be supposed to safeguard the whole class of employed people. So these are the 2 areas which I believe, read, understand from the concerned people, that where little there is hue and cry that this may change. I have sent one economics time cutout that 75% instead of 50% should be part of CTC, some kind of thing. So I mean, this is the area. But having said so, you from the industry side, having I from the government side and involved in articulating all these things, I agree entirely. It is a balanced piece of code, and the one who were left out from the ambit of traditional labor laws and schemes, efforts are made to safeguard their rights, and untouched area being occupational disease, my subject of PhD, which was really untouched, has been really addressed properly. When these things will be rolled out, we will certainly see the fruits of it, and so on. Because before I conclude, finally, Manish Singh ji, I understand the time runs out.
No, sir. Don't you worry. Please complete your content. Content is more important, sir.
Yeah, because
we have time. We have time. Don't you worry, sir.
So in 2018, ILO has circulated a research study and statistics that every year, in the year of 2000, about 29 lakhs workers in the world died due to occupational injury, disease, and so on. And to address their issues of, be it a compensation, medical treatment, reskilling the one who has unfortunately died, employing new people, almost 4% of the GDP of the world economy was spent in it. So, and all this could have been averted if things have been put in practice what has been legislated under the existing labor laws. But it needs to be given a more focus, in current situation. Honestly speaking, we are not aware about the quality of food we are eating. At industrial workplace, the n number of occupational disease would have been there, but there is no scientific systematic study. So in OSH code, expressive focus on research, survey and study also have been legislated. Policies there may be
madam.
any, I honestly repeat, but policy are
ये मेरे को ऐड करने की जरूरत नहीं होगी मैडम. You can come already directly now.
So teethless policies are only policies. Once it is legislated, it has a teeth, can penetrate and compel somebody to force. So there is one question, incidentally, from one of the student of Gujarat Vidyapit, that overtime will be applicable for managerial and supervisor. The answer is always yes. I mean, that is why the term has been included, to safeguard, because somebody is a president and puts 4 hours additional work and then nothing he gets at the end of the day. So let rules to come out. You see, friends, today we talk of Trade Union Act 1926, we talk of minimum wage 48, ID Act 47, Standing Order 46. But as many as litigations are there, as many as judgment contrary to each other we see and visualize. So that is ongoing continuous process. But the idea, intent behind putting all this which I have deliberated so far was certainly to safeguard the interest of all employees. Right? So that is how it is.
Thank you, Bakshi sir. In fact, yes, I did mention that we may have some limited time to cover a lot of topics here. But it's good that you had covered all the points which we have had for today, sir. Before we take on certain questions of our guests and participants here, I would like to request and invite Viralji once again. I believe Viralji, Dr. Bakshi has covered all the points which anyone would have. I believe since you look after the HR function of such a great group, there are a few questions you may have, perhaps by now have come in. Why don't you please would you like to ask these questions to Dr. Bakshi?
Yeah, I think one question which is coming in my mind, because rest of the questions is resolved by Dr. Baxi himself during the conversation, that is related to the abolition of labor code and then the balance view. The one question which is there is that there is no reference in this code with reference to the Shops and Establishments Act, whether this will continue or not. So that is again a gray area for me especially. Can you just enlighten, sir?
Yeah, I will let you know. I will wrap up with another question which Margi madam has put into the chat box.
Yeah, on post.
So first of all, Viral bhai, I will address your question. See, the labor subject is on a concurrent list of the Constitution of India, and the Shops and Establishment Act, which was repealed in 2019, which stands. It has nothing to do with the 4 codes. That is very clear. It is to regulate the employment of employees employed in the shops and establishment, and which you will agree by and large falls within the definition of unorganized worker, because mostly in shops and establishment, except hotel, restaurants or some other place, you have 10 or more employees, then that follow under the code on OSH, where some of the contractual employment or something, they need to get registration, and once they come under the ambit of that code, they are automatically governed by whatever is written in that code. Major chunk is the below 10, that is 9 and onward. They are governed by the Shop Acts, and they will get benefits of the all unorganized worker related issue in the given thing. So that stands, that is very clear as of now. Now
Okay.
with reference to what Margi madam has said, that POSH Act or Apprentice Act, are they part of this code? The answer is no. There is no mention. Only 29 codes, 29 existing laws are that I don't see any reason that there will be any integration of this POSH Act, because POSH Act is not the labor law. In fact, it is implemented through district administration. The Act of 2013 has its own, hierarchy of situation. So it is not a labor law as of the classification of the work to the Labor and Employment Department. It is not disputed that it falls within the ambit of some kind of misconduct, which if we read with the standing orders. But so far it is not within the classification of work assigned to Labour Ministry, assigned by Labour Ministry and assigned to Labour Ministry by Government of India. And Apprentice Act is, mainly to generate the, skilled manpower. So compelling all the industry. So that's a different set of thing. And one Mr. Chopra has said that shop and establishment is state act and not amended by the central government. But the government of India cannot amend the state enactment. It is a state enactment being labor on the subject of, concurrent list. So it is a state keeping them, so government of India has no role and responsibility to touch that legislature as of now in a current state of affairs. And of course, Margi Madam has said that there is some issue with the registration of unorganized worker. I do agree there are issues. In 2015, government of Gujarat has come out with the e-Shram card, that, but then it has not delivered. The thing being mass is 2 men and 93% of the workforce is informal sector, and everybody were having a feeling that if I get registered under this, I'll get all benefits between sky and the earth. So that was also the myth, and there was a big rush. Everybody used to have that card and something like that. But then there are parallel schemes which safeguards. I'll tell you before I quickly conclude what I want to address about the e-Shram card, that there is one official publication in Gujarat titling Vanchitona Vikas. It is a compendium of the various social security schemes implemented by various departments of the state, that includes education assistance, maternity benefit, those who are out of the ambit of this legislative part, the life insurance, death benefit, Awas Yojana, and so on. And of course, Ma and Ma Vatsalya, now today the Honorable PM has merged with the Ayushman Bharat and has been rolled out. So integration of the all health related scheme. So that is all what So that is the benefit to these. Who will get benefit? What will be the amount of benefit? What is the eligibility criteria, etc. So that's how e-Shram card related thing.
Bakshi sir, there's one question from Mr. Bhatt as well. Could you take that one up? Could you see that, or shall I repeat for you?
Yeah, please.
Mr. Bhatt is saying they have kept 50% as basic for attracting PF, etc. But as it's learned that liability of PF, etc. comes to more than 50%. Is it true?
Well, you see, the definition of wage is as being put here is basic, DA and returning allowance. Normally, in CTC, everything they include, and so whatever in excess to this amount of basic, DA and returning allowance is a perquisite. If it exceeds that, then excessive part will go to the basic, DA and on which PF will be deducted. So liability of PF will always be increased. Lot of companies have started working on it, to how to restructure the finance, HR policy and pay perquisite related probable load due to this code whenever it will be rolled out. Viral Bhai has already done this exercise. He's been doing since last 2 years under assumption that code may be rolled out in October, now in April 2022, so on. So that will be always there, and that was the meaningful changes to my mind that how I as an employer can pass the constitutional liability on the given, employer. Now, Margi Madam has put one, that misconduct and sexual harassment are cross-referred in both the respective act. To begin with, I will quickly say Industrial Employment Standing Orders Act 1946 is applicable to only those industrial establishments which are registered under the Factories Act 1948. It is not applicable to any other establishment, be it IT sector, shopping mall, multiplex, which are registered under the Shops Act of 2019 as repealed in 2019. However, the giving effect of this, the sexual harassment, as it is a misconduct, there is expressive provision in the POSH Act, to best of my memory in section 11, that it is also misconduct. Over and above the violation of, sexual harassment, it is also misconduct. So that is how it is, right?
Okay.
Yeah.
Then we have one more question coming from student. That's very good to see students are taking active part here, sir. And the one student who is joining us from Gujarat Vidyapeeth, Mr. Nilesh Karangia. He wants to ask you, sir, after implementation of these codes of wages, overtime will be applicable for managerial, supervisor category or workers, and FNF settlement also will be done by 2 working days, but specifically it is not possible. So what are your thoughts and answers, sir?
Yeah, I said probably the learned student would have gathered what I have said. Probably that is why the definition of employee was put in practice, that overtime and everything, if any hierarchy employee does, should be given the benefit of it, because being highly educated and having some different hierarchy should not be debarred from the constitutional right. If he does overtime, he too sacrifices his family time. So that needs to be compensated. That is clear intent when the code was drafted, and I was part of the interactive group, so I am very consciously sharing this. So that stands.
Okay. Mr. Bhatt has got another question to ask, sir.
Yeah, it has to affect the leave encashment and gratuity, certainly.
Yes,
Nothing,
yes,
you see, there are 2 schools of thought, Manish Singh ji and Viral Bhai will immediately agree, even Jaideep Bhai also, that if you think from the employer side, you will feel that this is liability. I have to sell out more money when the bonus limit is increased. Then it is a wage, then the gratuity will increase. Then PF, I will have to sell out more money. So is the leave encashment. Certainly it has to affect, but then, putting constitutional liability, I strongly believe, what is the intent? Whenever everything are legislated, there are some intention. It is not just a work for the doing a work.
Sure.
You will agree, Manish Singh ji, I understand you are the senior chartered accountant in the system. Correct me if I'm wrong.
Sir, I run few of the startups, yeah. I'm so sorry, I'm not a chartered accountant though. But yes, I do agree with you, sir.
That, as an entrepreneur, can you afford to account the constitutional liability on the workers? A cost to company, workers or employees are not raw material. They use 4% GST, 18% excise,
Correct.
and ABCD. You see?
Correct.
So that was the intent, that please equate them as the real, think tank in the organization and reward them.
Correct. Very correct, sir. Very correct. Very correct.
So that is how the intent was.
Great. So I come from an IT side. I have a couple of startups on IT side, and we have been having an employee size of around 100 plus and all. Honestly speaking, we never ever had thought of such labor laws and how does this affect in our industry also. Of late in the last 6-7 years, when we've been into our hands into this thing. But great talking to you today, sir. There are a lot of things which have actually, a lot of myths have got cleared. So with our participant today. Let us take one more question if somebody has before we get to the conclusion of this learning series today. Any questions, participant, you would like to ask? Please raise your hand. Any question to Dr. Baxi or even for our industry colleague Viralji as well? Okay, I think they're pretty satisfied today basis whatever questions you have already covered, Dr. Baxi. So I don't see any. Okay, this Dr. S.K. Chopra ji is asking likely dates for the implementation, although Dr. Baxi has already answered, but however, Mr. Baxi, if you can please cover it once again.
Yeah, the Viral Bhai has been doing lot of groundwork anticipating this code may be rolled out at any time as the head of the HR in his organization.
Correct.
Only a gray area which print media and my interaction reveals about what Jaideep Bhai has been worried about, that employer has to shell out more money if they pass on the 50% to the employee class. They are asking that 75% kind of thing. There was a display in economy. It was an official press release kind of content. So that's only the gray area. And what trade unions have been saying that the criminality has been diluted and composition of offences has been put in practice are two areas which comes on the surface that literally troubles this rollout of this code. But very honestly, as whatever reading I have, it is nothing like the agriculture law. And we have heard the very fair remarks from Viral Bhai without getting bias and prejudice. He has put 3 decades, so very reasonable, rich experience. I know him. He was with multinationals for a few years and so on. So it's nothing personal, nor he has drafted the code, nor so I have much affinity for the code being instrumental in doing all drafting. At some point of time, it's a judicial thing that it is a balanced piece of things. Something may go here and there.
Correct.
So, but sooner or later it will see light of the day. There is nothing great worth agitating for either of the stakeholders.
Okay. Thank you, Dr. Baxi. All the participants today who could join us, we have one announcement to make. Soon after this session and the way you are giving your feedbacks here, that gives us motivation to again come back to you with the same topic and have more detailed discussion on that in a workshop form, which is going to be probably next month. Those who have shown interest during a registration form, it's good that we have noted and we'll soon be coming back to you. Should there be anybody who would like to come back and would like to join this day's workshop, wherein again Dr. Baxi will be spearheading, you please feel free to contact me, and I'm going to put my email ID here. We'll definitely reach out soon. We'll happen to finalize that, and we're going to have the series both in other places like Ahmedabad, Vadodara, and even Rajkot over a period of time. So this is what a piece of information I had to share with you. Unfortunately, my chairperson and vice chairperson both are traveling, so they could not come on board and have words with our esteemed panelists today. So I'm going to do this needful on their behalf. Thank you so much, all the participants who could afford, who could come and spare some time today and grace this meeting. Also, I would like to extend my special thanks to my panelists, Dr. Baxi and Viralji, for sparing their time and gracing this meet today, this evening. And I would definitely, on behalf of ISTD, would like to welcome you again and look forward to have an opportunity to have you again on board with similar topic or some other topic which is relevant to the industry, which they can be benefited out of your rich experience and knowledge in the HR field as well as the labor laws. Thank you once again, gentlemen, for joining us this evening, and thank you all, one and all present today with us. Thank you once again, and have a lovely weekend. God bless you all.
Thank you very much, and it is our pleasure to join. Thank you very much.
Thank you very much, sir.
Thank you, Baxi, for your inputs. Thank you, sir. Thank you, Manish, for inviting.
Sir. Thanks. See you then again. Have a weekend, sir. Have a nice weekend.
Thank you.
Yes.
Thank you.